Hello friends, my name is Nizamuddin Ahmed Siddiqui and I am an assistant professor of law at West Bengal National University of Juridical Sciences, Kolkata. I will be taking this unit on future of fundamental rights on behalf of the content writer Dr. K. Sita Manikayam, assistant professor, Dr. B.R. Ambedkar Law College, Andhra University. This unit will aim to fulfill certain learning objectives, which include: number 1, an appreciation of the development of fundamental rights in the Constitution and out of the Constitution. Number 2, gaining knowledge about enlargement of fundamental rights for the future development of human being. Number 3, appreciating the idea of fundamental rights for better living. With these learning objectives in mind, friends, let us first look at the basic issues which will be dealt in this unit. The Constitution of India, drafted approximately the time at which the Universal Declaration of Human Rights was drafted in 1948. It therefore captures the idea of human rights as its best. Starting with the preamble, the Constitution has separate chapters on fundamental rights and the directive principles of state policy. Despite the reality that most of the human rights initiate clear expression in the Constitution of India, the Indian state approves the continuance of many colonial tendencies and power structures. Although the Indian state under Jawaharlal Nehru took many positive steps and followed a welfare state, representation within the police and bureaucracy remained mostly colonial in the approach. In the first 15 years of the Indian Republic, such contradictions inside the Indian polity were polished over by the euphoria of nation building. An agenda usually certified by political parties, the middle class and the privileged civil society. When the Indian state began to restrain such terminology of political revolt and milli rebellions, the violation of human rights by the state began to grasp awareness. After a phase of 30 years, the expression and affirmation of human rights within civil society resulted into a much more affluent, more varied and comparatively more influential conversation at many levels. There are 4 precise trajectories of human rights discourse in the Indian context. Number 1, civil and political rights. Number 2, rights of the marginalized. Number 3, economic, social and cultural rights. And number 4, right to transparent and accountable governance. Even though each of these trajectories are interrelated, they are promoted by diverse set of actors at different points in time and space. The constitutional guarantee of the human rights in our nation was one of the determined demands of our leaders all through the freedom struggle. It was completed as far back as in 1895 in the Constitution of India Bill, popularly known as the Swaraj Bill, which was inspired by Lokmanya Tilak. The order was repeated in Mrs. Annie Besant's Commonwealth of India Bill, which was finalized by the National Convention of Political Parties in 1925, by the Motilal Nehru Committee in 1928, at the Karachi session of the Indian National Congress in 1932, and by the Tej Bahadur Sapri Committee in 1944-45. Great legal luminaries of our country participated in the debates over the concept of the human rights back in 1950. it is through such debates that Part 3 of the Constitution on Fundamental Rights evolved. Taking lessons from the Irish Constitution, certain other rights came to be incorporated in Part 4 and were called the directive principles of state policy. Friends, let us now look at the manner of development of fundamental rights in India in the past more than 50 years. The drafting of the chapters on fundamental rights and directive principles by the Constituent Assembly was finished in the year 1949. By that time, the Constituent Assembly perhaps had before it simply one significant deed geared up by the United Nations, particularly the General Assembly Resolution on Universal Declaration of Human Rights 1948. The Universal Declaration enlisted a list of all the basic human rights currently described as civil and political rights on the one hand and the social, economic and cultural rights on the other. That was the circumstance when our Constitution came into force on January the 26th, 1950. But since 1950, there has been significant growth of human rights covering various issues. Human rights came to be divided, however, unfortunately, into two groups and were brought under two separate covenants at international level. The International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. It might also be consequential that all through the last decades, the Constitution of India has been amended on a number of aspects. In particular, the chapter on fundamental rights in Part 3 and the chapter on directive principles in Part 4 have suffered frequent amendments from time to time, including judicial interpretations. The chapter on fundamental rights in Part 3 has been amended in the last 50 years on more than 10 occasions. It is essential, therefore, to note that several of these amendments, and in particular the Constitutional 25th Amendment 1971 and 42nd Amendment 1976 to the chapter on fundamental rights in Part 3, gradually brought imbalances in the relations between fundamental rights and directive principles of state policy. Validity of such differing interpretations have been contested many a times. At once, individual fundamental rights seem to give way to serve the larger interests of the community, which was spelled out in great detail in the chapter on directive principles. However, at other times, it was stated that if the restraint on the fundamental right was for the purposes of giving effect to certain social and economic policies enshrined in the chapter on directive principles, then the restrictions imposed by law on those fundamental rights could not be struck down by the courts as unreasonable. Some of these amendments to the Constitution were upheld, while some others were not accepted by the Supreme Court. The Supreme Court of India has acted proactively towards the development and has moved forward to enlarge the fundamental rights, while constitutional legislation has lagged behind. The court has interpreted the word life in Article 21 of the Constitution to constitute within it the right to live with human dignity, the right to clean and healthy environment, right to education up to 14 years of age, right to medical aid, right to health, right to shelter, right to livelihood, right to fair and speedy trial, and right to free legal aid, right to compensation, rights of children, rights against torture, the rights of prisoners, and the list goes on. In chapter 3, friends, we have anticipated enclosure of diverse economic, social, and cultural rights. In this part of the Constitution, there are a few other important human rights which are equally fundamental, such as the right to work, health, food, clothing, housing, education, and culture, as I have already mentioned, which must be taken concern of. These rights are vital to the weaker sections of our society and cannot be left at the periphery of our consideration. In reality, some of these rights are also enclosed in International Covenant on Economic, Social and Cultural Rights 1966. While these rights cannot be included in Part 3, it is felt that a method needs to be introduced which will formulate sufficient funds accessible for awareness of these rights. The expenditure of providing shelter, education, health care, and social services needs to be taken care of. It is a huge amount, but approximately equals to the same that the world spends on arms in just 2 weeks. The ICSCR, to which India is a party, requires step-by-step or progressive realization of these rights, and the state is required to set apart the greatest of its available assets for this purpose. These economic, social and cultural rights are spelled out in great facet in the Covenant. Article 6 of the Economic, Social and Cultural Rights Covenant refers to right to work, Article 12 to right to health, Article 11 to right to food, clothing and housing. Inasmuch as Article 35 of our Constitution expressly provides that the directive principles referred to in Part 4 are not enforceable through the courts, it is all the more necessary to provide a separate machinery for the realization of these rights. Article 12 of the Economic, Social and Cultural Rights Covenant requires the state to identify the right of everyone to the satisfaction of the highest achievable standard of physical and mental health, and that the state shall take steps to ensure the decline of the stillbirth rates and work for the healthy improvement of the child, the improvement of all aspects of environmental and individual cleanliness, control and suppression of work-related and further diseases, and the creation of circumstances which will guarantee to all medical service and medical attention in the occurrence of sickness. For instance, the right to health is not a right to be healthy. It means a right both to certain freedoms and entitlements. This freedom comprises the right to control one's health and body, including sexual and reproductive choice, and the right to be free from intrusion, such as by non-consensual medical treatment and conducting tests. The entitlements include a right to a system of health protection with equality to opportunity to benefit from the highest achievable level of well-being. Similarly, Article 13 of the Economic, Social and Cultural Rights Covenant deals with the right to education. We have referred to Article 13 in this unit while discussing the ICSCR. So far as the primary education up to 14 years is concerned, similarly, Article 13 of the Economic, Social and Cultural Rights Covenant deals with the right to education. We have referred to Article 13 in this unit. so far as primary education up to 14 years is concerned. As stated earlier, it has to be free and compulsory. The International Covenant on Economic, Social and Cultural Rights recognizes the right to the preservation of culture and its development. The UNESCO Declaration of the Principles of International Cultural Cooperation, 1966, speaks of the right and the duty of all citizens to expand its culture. Other UNESCO instruments like the Hague Convention for the Protection of Cultural Property in the event of armed conflict, 1954. The 1964 Recommendation and Convention on the Means and Prohibiting and Preventing the Illicit Import, Export and Transfer of Ownership of Cultural Property, 1970. The Convention concerning the Protection of World Cultural and Natural Heritage, 1972, and the Recommendation concerning the International Exchange of Cultural Property, 1976, also aims to protect cultural and natural heritage. The UNESCO's role to the safeguarding of monuments and works of fine art has been predominantly striking. Its 1980 proposal with reference to the status of the artist seeks to look after the cultural and property rights of artists. Article 51A of the Constitution similarly talks about the duty of every citizen of India to value and preserve the rich heritage of our composite culture. Article 49 of the Directive Principles provides that the state should guard monuments, places and objects of national relevance. For protecting culture in all its statistics and in increasing, the state must set apart essential assets. As to the association of this organization, it should be a high-profile body consisting of planning and finance experts and experts linked with each of these subjects, specifically working on health, food, clothing, housing and shelter. The Constitution and its functions and the enforcement of its recommendations ought to be provided by a separate law to be prepared by the Parliament. The Union Government, the state governments, the Planning Commission and the Finance Commission, including the state planning and finance departments and other planning boards, are required to offer due burden to the recommendations of the organization and create suitable allocations year after year for the progressive apprehension of these rights as enshrined by UNESCO. Friends, we are now going to conclude this unit in a couple of minutes, and therefore it needs to be emphasized that the fundamental rights included in the Constitution are to be considered essential for the development of the personality of every individual and to preserve human dignity. Most of these rights are enforceable against the state by way of their language, while some others are directed both against the state and private actors. The most important feature, however, is that the fundamental rights has given the higher judiciary a clear set of criteria to regulate relations between citizens and the government, as well as between citizens themselves. Furthermore, Indian courts have interpreted these rights not only in a negative dimension, as we have already seen, but also in a positive dimension. The right to education, food, shelter, work, clothing have emerged as fundamental to every individual. When the state gives importance to these rights, the constitutional goals are rightly fulfilled. Therefore, we need to emphasize on this aspect. Friends, with this we come to an end of this unit. I thank you all for listening to the lecture with patience.